Yes, let's begin. But I was going to deal with the question of the service, whether it's proper or it's not. We'll come to the more important other issues rather than bury all of this under.
You have seen the proof of service, right?
Yes, I've seen it.
The proof of service.
Served on their lawyers. So it says. Correct.
Good.
So, Inusah, let's hear you also have your analysis.
So, on Thursday morning, I was driving home from a program I had on the sister TV station when I heard that a group of young men who had come out to demonstrate against the government had been arrested and sent to the police station. I didn't know the police station, so I had some stirring in me, and I was emotionally drawn to their plight. So I moved towards the police headquarters. And when I got there, they told me that they had not received any demonstrators at the police station, and so I should check. They directed me to another office. On my way there, I called somebody, in fact, Edoji Tamaklo, who said, "Oh no, they are not at the headquarters, they are at the Greater Accra Regional Command," and also gave me the number of one of the demonstrators. So I called, and he confirmed that they were at the head office. I went there. Now my issue simply is this. The Public Order Act is a 10-section act. It's a very small act. Now read the whole act. Offenses under the act have been provided. A person who commits an offense under the act has been provided. The power of the police to arrest without warrant has been provided. So in any other offense under the act, it must be on notice. You must issue a criminal summons. The only time that the police have the power to arrest without warrant, it has been provided. Now, so I felt that what the police had done, arresting the people without a warrant, clearly was unlawful. Now, why is the Public Order Act designed in that way? Sparse, not extensive. Because there is a deep recognition and appreciation that you are trying to enforce the enjoyment of a constitutional right as part of the Chapter 5 rights of the Constitution. And so if you put too much fetters, you might be unwittingly denying, clawing back that right that is provided in the Constitution. So the basic thing one asks, so when I got there, I asked them, "Well, have the police, did you notify the police?" They said yes. "Did you indicate the route?" They said yes. "Did they suggest a postponement or an alternative route?" They said no. They said no. Even though I've since seen facts that they say that the police have issued that they met them. But they said no, they didn't. They said, so you have not, there's no compliance, they have not complied with Section 3 of the Act. They've not requested of you to change your route. They said no. It's okay.
Really?
And so if they have not done that, and you have not, because they have not done that, you didn't have even the opportunity to refuse to signify your unwillingness to conform with their request to change the route. So, because they didn't. So you see, then I then questioned the motion, the application for an injunction. When you read section 1, subsection 5 of the Act, subsection 5 of the Act, or 6, where the organizer refuses, and the organizer includes organizers, where the organizer refuses to comply with the request under subsection 4, which is to change a route or fails to notify the police in accordance with subsection 5, the police may apply. So there are clear conditions precedent. This reading simply tells you that the police have no power or authority to go to court for an application to prohibit a demonstration if they have not exhausted the remedies in 4 and 5.
So, but they said they did it.
No, I'm just saying. So that was where my fury was arose. That look, why will the police do that? Because clearly, if you have not done that, then it's, and you know we are lawyers, we act on information and belief.
Yeah, sure.
So my clients informed me they have not, so I believe them. Okay? Then I said, well, but in any case, Larry, what were they out to achieve? Even if the police had complied with Section 4, even if the police had, the demonstrators had not signified their willingness not to comply or their unwillingness to comply with the request, even if they had been served with an injunction, an application for a prohibition order, what were they seeking to achieve? Now, J.F. Kennedy in 1962 said some words, a sentence or a statement, made a statement that is poignant to what we are discussing. It says, those who make peaceful revolutions impossible will make violent revolutions inevitable. These people have set out to go embark on a peaceful demonstration. Young, idealistic people who think that the situation that confronts them now and Ghana as a whole does not point to a bright future. Larry, me and you are citizens of this country. Government is our agent, because all of us cannot be at the Jubilee House. So we say, well, because we want a democracy, and the vehicles for getting elected into an office is to join a political party and bring your manifesto. So parties do. Then we elect them. By electing them, we are consigning them into our agents. We are the principals. And tell me, what law prevents a principal from telling the agent that I feel dissatisfied with what you are doing? I don't like what you are doing. And if they go to that place and picket and draw attention to what they perceive as what in their view is gross mismanagement of the economy, what is in their view is a compromise of their future, what is in their view is an unjust situation that's been perpetuated on them, what is wrong with that? Assuming, but even before I come there, you know, two legal principles have obtained a sanctimonious status. One, consequent upon the Nuremberg trials, there's a legal principle that now says that no one has a duty to obey an unlawful order. No one. And that is so if an order is made which you have reasons to believe is unlawful, and you obey that order, you cannot now say that you cannot be held vicariously responsible for the order that was made. That was the foundation upon which all the officers who carried out Hitler's orders to exterminate the Jews were held responsible. They were not acting on their own. They were acting pursuant to orders. Those orders were from lawful authority. Hitler had won elections and was the lawful authority in Germany. But the court said,
you have 1 minute.
The Nuremberg trial established that no one has that duty. Two, Lord Denny has said it time and again. You only have a duty to obey the lawful orders of a court. But out of respect to the courts, when processes are filed, we say because the court is human, why do you want to conduct yourself in such a way as to outreach the outcome of the process? Why don't you give respect? It's definitely out of respect. There is no law. You bear the consequences of your decision to ignore the process, but you cannot be held for contempt if a process is filed and you go ahead. But you bear the consequences. There's no law.
But there's some authorities that, to the effect that when you proceed to do the very thing the court say don't do, or the
court, no, the person is asking the court to prohibit you from doing, not the court is saying don't do.
Yes, but
that's what I said. the lawful orders of a court. But the processes filed are not orders of a court.
Yes, but when you proceed, yes,
you do that to your own detriment.
Yes.
But you cannot be held for contempt.
Oh.
Yes.
There have been several.
You have not acted contemptuous of the court. You have not only shown the level of respect.
Authorities.
My time is up now. I can ask you a few
so you
questions.
ask me a few questions.
Yes. Where you actually ended. You are saying that when processes are proceeding in a court or pending in a court, and you have been duly served with a notice of an injunction application, and you elect not to wait until the determination, you are not liable for contempt.
What contempt?
So you are saying
of the court.
You are saying our courts have all this while been committing people to contempt wrongly.
What contempt are you in? What contempt?
In that case, you don't have judicial precedent to support you that if I file an injunction application and I serve it on let's still go back to the land issue. You are about to build. I argue that you say you have bought the land. I say I've also bought the land. And we say, let's have a court to settle the matter. And we have been served with an injunction process so that you hold on and you continue to build. And I take you back to the court and cite you for contempt. You are saying that the court cannot hold you for contempt.
For what contempt? I'm not contemptuous of court.
What I mean is that you can't find judicial authority that supports your case.
I'm saying that if you go to court for contempt, you will find.
No. The one saying you will not be held for contempt.
I'm saying that I've just given you an authority that Lord Denny, in his writings, have indicated clearly that anybody. What I'm saying is that.
Please, let me do the questioning.
What I'm saying is that Lord Denny has said clearly that the duty you have to the court is to obey the orders of a lawfully constituted court. It's clearly.
And our courts have said that if an injunction application is served on you and you proceed to do the thing you are being injuncted from doing, you have taken the job of the court. There's nothing for the court to adjudicate over again, correct?
The court,
therefore, you'll be punished for that.
There is. Your punishment is, taking the consequences of your action. For instance, if it is a land case, and then there's a suit, and then you continue to build, the court will order that you will not be given what we call, if you invest in the land, okay? Because every court frowns upon unjust enrichment.
That's correct.
Good. So if you invest in the land and there's a dispute, and you show clearly where you got a title from, and you were under the belief that the document that you had gave you a right to that land, and you have made investment, the court in pursuing justice might say, well, you have invested in this land, you've cleared the land, you build a wall around the land. So yes, but your title appears to be defective. You don't lose all. Do you still need the wall? So you will be compensated for whatever investment you have made. But if there was a process filed before you started building the wall, before you started clearing the land, you have taken the law into your own hands and you will bear the consequences. But you're not in contempt of court.
You're very familiar with this very important authority that the courts have reaffirmed over and over again, 1971. It is good law and it remains the law we use in Ghana. What you say here this morning, that Lord Denning has said, will not change this law.
It will not change.
So as lawyer, you may be minded not to mislead a member of the public, that when injunction application is served on you, you can go ahead without waiting for it to be determined, and you won't suffer for it.
You won't suffer.
Okay.
That's why the Electoral Commission is not going to suffer for it.
No. I think from where I sit,
you will suffer.
That is wrong law.
Okay.
Now, in Republic versus Moffat and others, Justice Saban said, and we keep this, it remains the law, it hasn't changed. Justice Saban said, I will be laying down a very dangerous precedent if I were to hold that a party, when served with application for an order of prohibition, that's injunction, from the High Court, can disregard or ignore the said application and treat the court with contempt, end quote. And this law, this is the law of Ghana. It hasn't changed.
No. So that's the law of Ghana.
Yes.
And Justice Aban drew his authority from where? Was it per incurium or he had authority to support this position?
So
No, I'm just asking. Please, because we are lawyers.
No.
We are lawyers.
Wait.
You have just quoted.
I think that is inconsequential.
It's consequential.
You see,
My time to engage you is up.
Well, okay.
My time to engage you is up. But I think the principle. Let's hear others. I was going to ask you about. You said, I think I'll make a little exception. You said the police had not raised any objection to the routes they were going to take.
Yes. That's
when the police issued the second letter.
Yes.
In midnight of is it Thursday, refuting the claims that they had not served.
Yes.
They attached a letter from the Democracy Hub. Did you see that letter?
No, I've not seen.
In that letter, which is from the Democracy Hub, they were writing to the police, telling the police that you have said we cannot use the Jubilee House, blah, blah, blah. We disagree, so and so. So, in fact, there was a disagreement. And the letter is evidence that there was a disagreement.
So, that's why I have said that even if there was disagreement, so I address your issues in compartments. Compliance with the Public Order Act. And even if there was non-compliance, is that the punishment under the law? And I quoted for you the statement by J.F. Kennedy. This was properly situated within the context of civil disobedience. If we bring it back, that look, there is, there is an extrajudicial something. The law says we shouldn't do it. You have said we shouldn't do it, but we'll do it. So you take the consequences, okay? But civil disobedience have been known to have been used for many. Our own independence, Sergeant Ajete and Co. The fact that they confronted Emery, who had prohibited their assembly, did not prevent them from meeting and did not prevent us from getting our independence.
Right.
Or the Kumu Press demonstration had been outlawed, they had said don't carry it out, but because they wanted it for a purpose. So you have to look at the justification is in the value that thing.
Thank you. I want us to be as brief as possible. And the next issue I want to raise with you, because our next guest, there's no lawyer among our next guests, I suppose. So I want you to help deal with this. The police said they sent the application, not the court order, the application to the lawyers for the Democracy Hub. In their letter, in their press release, they state that in their correspondence with the Democracy Hub, they indicated that Atukba and Associates are their lawyers. So if you want to do something, you can deal with them. So because of that, they filed the process and got the bailiff to go and serve it on their lawyers. Let's educate the public. Is that good service in law?
Under normal circumstances, because Democracy Hub is an organization, so it's not a natural person. So if they elect their lawyers, you serve the process on their lawyers, and that's good service. Now, but where individuals who can be identified are engaging or planning to engage in a demonstration, it is not Democracy Hub as that artificial person that is going on that demonstration. And so when individuals, and the law provides that the organizer of the demonstration is the person who signs, or are the persons who sign the notification request. Now, or the notification. And so I would have thought that when they sued the organizers, went to court for a prohibition order, they ought to have gone the extra mile to call the organizers or look for the organizers and serve them with the process, because they were going to march. They were going to be on the
So once again, for the purpose of education of our audiences, in law, as we know it by now by practice, if you and I have a matter, let's go back to the issue I use you and Gary as an example. Because you are fighting over the land, you make your lawyer write to Gary. Gary writes back to you. Gary at a point realized you are being incorrigible or something. You are not understanding. Obstinate. So he wants to go to court. Are you suggesting that if he files the originating process in court, he can serve it on your lawyers? Because by certain correspondence with your lawyers,
he has to serve it on me.
Okay.
That's what I'm saying.
There is no exception that an originating process should be served on a certain lawyer.
No. I'm saying that
the same rule applies here.
Yes.
The law in Order 12, rules, Order 7, Rule 12, is very clear. And it says that before a lawyer can take a process, which will become service, is that Rule 12.2, where a lawyer undertakes in writing to accept service of a writ on behalf of a defendant, the writ shall be deemed to have been duly served on that defendant when served on the lawyer.
Yeah.
And even in that, it is the lawyer who must write. And you don't write to the police, you write to the court and say, my client has waived his right to receive the process. He wants me, the lawyer, to receive it. Is that not correct?
That's what I'm saying. For me...
So the police service, speaking pure law, is non-service.
Yeah, you see, let's make two distinctions here.
That is the reason, for example, now, they may not be able to cite the organizers for contempt.
Even citing them for contempt, well, let's wait and see what happens.
Okay.